Good afternoon, everyone. Welcome to another edition of Ask a Lawyer Live. I'm Dave Brannen. It's good to have you here this afternoon. I'm just getting everything set up. Got my dogs all taken care of, and hopefully we're in for a good hour or so of just talking about CPP disability. I'll also save some time at the end where I can answer any type of questions that you may have. It doesn't have to necessarily be with CPP disability. All right, so I think let me see here. So if you haven't been here before, this is a weekly live show, or sorry, a daily live show that I do during the 5 days a week, where on Monday, I usually talk about a CPP disability topic. Today's topic is going to be disability and employment income as it relates to CPP disability. Can you work while getting CPP disability and stuff like that? Um, but I'll also do some questions. And tomorrow, I forget what my topic is tomorrow, but it will be on a long-term disability issue. I'll look it up here before we get done the stream today. And on Wednesday, I will be talking about an employment issue, kind of an employment topic. Thursdays, we keep open for just any type of live Q&A. And Fridays, I usually try to bring a guest in, but may not be able to get a guest every Friday. So I may just do an open Q&A, or we'll take the day off. We'll just kind of play it by ear. All right. So what I would ask you to do is if you have any questions, just put them in the chat. That's how I can see them. If you could put a Q standing for question in front of your comment, that way I know it's a comment, or sorry, it's a question to me and you're not just commenting to other people in the chat. That's pretty much it. So let's get into this. So the topic today is, can you work while getting CPP disability? A lot of people ask us this. It's a great question. Some people assume that you cannot work, and those people would be incorrect because you can. Let me just make this a little bigger. There we go. Getting the bugs worked out here. And I will say, as I've mentioned before, what I do is I do these live streams. I do the presentation as part of the live stream, but I'll be clipping these out and posting them up as their own individual video. So I'm just going to start over just to get a little bit of a better introduction for this, and then we'll dive in. So you kind of get to see how the sausage is made here, and you can be part of helping me make these videos. So let's take it from the top. Can you work while on CPP disability? That's going to be the topic of today's session. And here we go. So what we're going to cover is, can you work while getting CPP disability? What counts as employment income? And how much you can earn and still keep your benefits? These are three questions that people want to know. And by the time you leave this session today, you will understand answers to all of these things. So first of all, what is CPP disability? Just as a kind of an overview, CPP disability is a monthly benefit that's intended for people with a severe and prolonged disability. It is meant for people who have an inability to work regularly. Now, we'll come back to this idea of regular work, but being able to work on a regular basis is one of the key things here. To get CPP disability, you must also have made recent contributions to the CPP program. This is not a program available to everyone. You have to have made contributions, and you have to have had recent contributions in relation to when you had the onset of your disability that prevents you from working. All right. So I'm not going to bury the lead here. Yes, you can do limited work while still receiving CPP disability. That is allowed. Now, what you have to be careful of is if you start to show that you're working on a regular basis, that could be a red flag and cause you to be reviewed. So demonstrating capacity to work regularly is going to be an issue. That's going to be something that Service Canada is going to look at. What they're worried about, what they're looking for is your ability to be able to do gainful employment. Gainful employment is something that is defined specifically for CPP disability. It's not a general notion of gainful employment. They have defined it as being 12 times the maximum monthly benefit that someone can get. So each year they take whatever the monthly benefit amount is, they multiply it by 12, and they deem that to be gainful income. So right now it's around $20,000 or so. So they're constantly assessing, is this person demonstrating that they can work regularly enough to earn $20,000 a year? So that's what you need to be able to keep in mind when you are doing any type of work and continuing to get CPP disability. Now, what counts as employment income? So this is important. Not all income is the same. What they're concerned about is your active engagement in work or income that is coming from from active income. So things that would be active income would be things where you're doing something in exchange for money. So like salaries, T4 income are obvious ones. Self-employment income, even if it's under the table, money is considered employment income for the purposes of CPP disability. Commissions, tips, any type of work from selling crafts online, doing gig work, anything like that can be, as long as it's work in exchange for something else. You're either selling a product, a craft, you're doing some type of work. This is all considered employment income or self-employment income for CPP disability by Service Canada. Even sometimes if you're doing volunteer work, this comes up sometimes. So people do volunteer work and they will give you something in exchange for it. You have to be careful about that because that could very well be considered employment income, even if they're giving you like an honorarium or like an honorarium or a stipend, I guess the word I'm looking for. So any type of a payment where you're getting something for volunteering, you have to be careful. If it's just reimbursing you for travel expenses and things like that, that's not really, I don't think you'd have an issue there. But if you're getting an honorarium and things, that can be considered income. Now it's probably not going to be enough that it's going to matter, but just keep that in mind. The ones where people usually ask me are, okay, David, what about things like I rent out a room in my apartment or house to someone else? Is that considered income? The answer to that is generally no. Rental income, where you're renting out a room in your house or 2 rooms in your house or something like that, is generally not going to be considered income for the purposes of CPP disability. But there can be situations where you have rental income where you would be deemed to be engaged in active employment, and it would be seen as, they would count it as income. That would be situations. So it's not always a clear line, but the more it moves from, I just has a couple people renting out rooms in my house towards I'm managing an apartment unit with 10 units in it, and I'm coordinating things, I'm collecting rents, I'm calling and arranging for things to be done. Once you're into that kind of situation, you are actually employed as a property manager. So what Service Canada and Revenue Canada, they're always looking on that spectrum. Is this just a person in their house doing like renting out some rooms, or is this person really a property manager managing investments and things like that are working actively within those property investments to earn the rental income? Okay, so keep that in mind. And there is a spectrum there. So there's a point where you will switch from one to the other. The more you are doing services for the people that you're renting to, the more you are going to fall on the side of it, this being employment type activity versus if you're just passively renting a room and they're coming and going kind of thing. The other one would be investments. So if you have passive investments like in the stock market or mutual funds and things, and you just get dividend checks and things, that's one thing. But it's another thing if you are engaged in day trading. Day trading is where you're constantly managing a portfolio, buying and selling stocks, buy high, sell low, whatever, probably the opposite, buy low, sell high, whatever. If you are actively engaged and you're managing an investment portfolio, then you are actively employed. Now, again, it's a spectrum, so I can't always say they will look for indications. Are you somebody just collecting dividends from passive investments, or are you actively involved in this enterprise of making money by managing an investment portfolio? That's where the line will be. All right. Let's look at the income limit. So for 2025, it's approximately $6,600. If you earn that much or less, you don't even really have to report it to Service Canada. However, any income over that can trigger a review. Once you get money over $6,600, it can trigger a review and they can look at the situation. They're always looking at, are you demonstrating any ability to work on a regular basis? Even if you're earning under $6,600, if you are demonstrating and a capacity to work on a regular basis, they may investigate it to see maybe you could work more, maybe you could earn more if you're showing that you're able to work regularly. Again, coming back to this idea of regularly, it means that you are capable of showing up and working on a regular kind of schedule at a workplace that you could repeat day after day type of thing, or 3 times a week or whatever it is. If you could come on a regular, predictable basis, that's often the reason people are deemed unable to work is their medical condition is such that they are incapable of working regularly. So it's unpredictable. They can't stick to a schedule. They'd constantly be calling in sick. You don't know what's going to happen one day to the next. If you're in that kind of situation, you can't work regularly. But if you're showing through your work, the work type of work you're doing, that you're showing up and working on a regular schedule, the more you're demonstrating you can do that, the more you could get assessed. I don't know how often they really do an assessment like this. In theory, they can, but I don't think they're spending lots of time scrutineering people who are making like $6,300 to see if they can work regularly. Quite frankly, they don't have the information. But certainly if you are over six, so once your income goes over 6,600, you do have to report it. If you don't report it, they're going to like audit you every now and then, and they will find it. So if you're consistently earning like 17,000 a year, and we know that the gainful threshold is 20, they're going to probably audit you and figure out, okay, are you purposely just keeping your income under the threshold, but you could work more? Or is this really the maximum of work capacity that you have? So those are the kind of things where they're going to assess it. They're going to assess people who are making over 6,600 but still under the 20,000. And the closer you are to the 20,000, the more they're going to watch, the more they're going to like scrutineer it. Again, the nature of their work and the frequency matter. So if you are just doing one-off things for crafts in this, like that is going to be different than if you are showing up for a shift, like you're doing a shift one day a week at a Tim Hortons or some other place. Like it depends on what you're doing, that they will try to take it from there. Could this be expanded that you would be able to do more of this and earn a higher income? If it's just you're doing one-off crafts and selling them online, making a little bit of money, then it's quite different. Certainly, self-employment income is a lot harder to figure out, and they will be much more suspicious of self-employment situations, especially where you are involved in a family business. So they know that with family businesses, you can kind of cook the books, if you will. There's a lot of ways to manipulate it to show that people maybe are doing work but are being underpaid. Like there's all kinds of ways around this. They'll be very, if you're involved in a family business, you're going to come under more scrutiny because of how difficult it is for them to really know what's going on, and people can hide money. I've had situations where somebody who was completely disabled on paper was shown to have worked at a business for like 20 years, right? It was her family business, her parents' business, and they just had her on the books as a worker, but she never did any work. So that created a lot of problems when you're now trying to prove disability after there's evidence that you worked and paid into the system and things like that. So that really got into almost like a fraud situation. So these are things where you have to be very careful and know that if you're in a family business situation, it's going to come under a lot more scrutiny. Okay, so work trial periods and reinstatement. I bring this up often, but if you do want to attempt to go back to work while you're on an approved CPP disability claim, it is something you can do. You just have to get in touch with their vocational rehabilitation program and let them know this is what you want to do. They will arrange things to give you time. There's a period of time, I believe it's about 3 months, where you can continue to work and get full pay from CPP. Sometimes that can be extended, I think, but they do give you a period of time where you can get both for you to try it out to see if it's going to work. If you go back to work and then go off work within 2 years, they will reinstate you right back on your claim. You don't have to reapply or anything like that. If you last longer than 2 years in the workforce before you kind of crash out and have to go back off completely, then between 2 and 5 years, you can have a fast process to get back on CPP disability. After 5 years, you're back to doing the same old application like anybody else. All right. So the key takeaways here are, yes, you can work, but you do need to be cautious about it. There are income limits that you have to be aware of, the 6,600, and the real focus is on whether you're able to work regularly on a consistent basis. You will definitely want to always disclose work activity to Service Canada, especially if once you get over, like, technically you don't have to report it if you're under the 6,600, but once you get over the 6,600 or get close to it, it does help to report to them the kind of work you're doing. It can maybe save you headaches, because if the type of work you're doing is very irregular, it'll make them more confident that this is not a situation where you could be working more and they have to do a deeper investigation. And if you have doubts, you can always seek legal advice, but this is one of these things where there's not a lot of legal advice to get unless you've kind of got yourself in a mess where you've been, like, we will get calls from people who have been working regularly, earning like either right at or over the $20,000 limit and not telling Service Canada. Once they find that out, they come down very hard. They're very aggressive, and they will bring lawsuits against you to collect the money back and all this kind of thing. So that is the time when people reach out to a lawyer, but by that time it's kind of too late. And people often have a lot of excuses, some of them valid and some not, but the most common one I hear is, well, I tried to tell them, I called in, I left it. Like, you really have to be persistent. If you just call in and leave a message with their system there, it may never get passed along. It's not enough for you to say, oh, well, I did my best, I kind of told them. You really have to keep following up. I know it sounds kind of ridiculous, but you do. You have to keep following up until you get an acknowledgement from them that they are aware that you're earning like $15,000 a year or whatever that you've told them. Then it's hard for them to come back and tell you that. Well, it's not that hard, actually. They can always come back. If you're earning above the 20,000, then they can always come back and make you repay. If you're earning under, they can try to make you repay some of the benefits. If they feel like, yeah, you're making 17, but you could really earn a lot more, then they could argue that you have to pay back your CPP money. That's why you don't want those surprises. You're better off to keep them well informed once you start making over the 6,600 a year. All right. Let's go back to this, and I'm going to take some questions if people have them. We already have one question here from Lee. Lee wants to know, can you get pension income and still get CPP? And if I have the disability tax credit, it means it's easier to get the CPP. So let's do the first one first here. So yes, pension income does not count as income against your CPP disability. So in other words, when I say you can earn up to 6,600, like, that doesn't include pension income. All right. So pension income is not included there. Second part here, if I have the disability tax credit, does it make it easier to get CPP? The short answer there is yes, because getting the disability tax credit does indicate that you have a significant disability, but you still have to prove that your disability prevents you from regularly working. There are worlds where you can have a disability for the disability tax credit that would not prevent you from working regularly. Although it would be hard to find out that situation, but that is theoretically possible. So one does not lead to the other, but certainly if you have been approved for the disability tax credit, it will make your CPP application much easier. If I were you as well, if you're applying for CPP disability, I would want to give CPP disability a copy of the approval letter that you got from Revenue Canada for your disability tax credit. And I would also want you to get a copy of the medical information that your doctor provided to the disability tax credit people. You could get that by requesting a copy of your file from Revenue Canada related to the disability tax credit. All right, let me take a little drink here and see if other people have any questions. I did a special session on Friday. I'm not sure if any of you guys were here, or on Friday, Thursday night. Thursday night, I did a special session on the Canada Disability Benefit. So I was talking about what to expect with that going forward. It's coming into effect here this summer. To get that benefit, let me see. I can probably bring up my slides ahead. Let's take a look. I can go over the slides that I did on Thursday. Let's see. Is that it? think this is it here. Yeah. So with the that's not what I wanted. Hold on, folks. Hold on. Let's see if I can find the better one. No, maybe that's all I got. All right. So basically, with the new regulations, they've come out with the eligibility criteria, and the key ones that kind of stand out as something different is you have to file your taxes for the year before. So if you plan on applying, well, and also the other thing is you have to apply for it. We were thinking maybe if you already were approved for the disability tax credit, you wouldn't necessarily have to apply for this new one, but it looks like from the regulations, they absolutely will have you apply. Now, your disability has already, if you've been approved for the disability tax credit, your disability component has already been predetermined. So you're not really having to apply on that grounds. I think the application for the Canada Disability Benefit will be more related to you just sort of giving them authority to contact Revenue Canada and do these types of things that they would need to verify your taxes, your income, and that kind of thing. So the application process is not out yet. That's supposed to come out, well, probably by May. These regulations take effect in May, so I expect the application process will be kind of laid out by then. You can qualify for benefits starting in June, and you can only be paid 1 month after the month you qualify. So payments would go from July of this summer, 2025, until June of 2026. They've laid out how payments will be determined. The maximum amount someone can get is $200 a month. And if your income is below 23,000, then if your income is below 23,000 and you're single, then you would get the full 200. Then there's a kind of a zone between like 2,300 and I think 3,500 where you can continue to get less and less amounts where once you reach 35,000. Once you reach 35,000, you would not be eligible. The amounts are slightly different. If you are a little bit higher, if you are in a common law or marriage situation, they would look at your combined income and it would be the same kind of thing. You would be able to get the full benefit up to, I think, what is the amount? I don't have it right in front of me here. Let me see if I can find it one more time here. Summary. Let's see. I can see the names of things, but can't really. Yeah. Try one more time. All right. Yeah. So this is the summary the government put up. This isn't the regulations, but it kind of goes over the things. So this will tell me what I'm looking. Yeah. 3,200. So if you are married or in common law, if your combined income is 32,500 or less, then you could get the full 200. Then thanks, Menia was trying to help me out there. I appreciate that. So then between 32,500 and it would be 32,500 and 44,500, you would continue to still get something, and it would just kind of be less and less up until that point. I don't know if anyone has any questions on this benefit or not, but that's pretty much so they're concerned about your marital status, whether you filed taxes. Those are the key things, and your income. Now, the other key point that is interesting to note is just like CPP lets you earn 6,600, they don't, you can earn that and still get the benefit. They allow up to 10,000 in income, which is great, in 14 if you're in a common law or married situation. So the first 10,000 of your income doesn't count. So really, you're allowed to earn not 23. Really, it's going to be like 33,000 because the first 10,000 won't count if it's coming from employment or self-employment income, which is interesting. That's interesting. That's a good way. I'm not sure why they do it that way. Why not just put a higher threshold? But whatever. That's how they've done it. I don't know if there's anything else here that was really that. There were weird things like if you are in a common law or married situation, like for you to be eligible, your spouse has to have filed their taxes too. So that can create kind of weird situations where like you have to try to force your spouse to file their taxes if they haven't done so. There are some exceptions in there that if we're looking at like domestic violence in different situations where you might not be able to force your spouse to file their taxes. But for the most part, that is something that you're going to have to be able to do. Oh yeah, here's a question that I didn't answer on that stream that I to further. That this question here is taxable LTD considered adjusted income. So this mention of adjusted income, the Canada Disability Benefit is focused on adjusted income. That is a word that has a very specific meaning, and it comes from the Tax Act, the Income Tax Act. There's a whole section on it in there. It's very complicated to read, and I am going to go through it and try to understand it a little more, but it's a very complicated section to read. It lists what they consider to be adjusted income. So it will include adjusted income, generally includes any employment income. And if you have had so it's different from your taxable income. Taxable income is your income after all deductions and things. So adjusted income is your income before all deductions. So deductions for like RRSP or whatever, medical expenses, all these types of things. So the question is going to be, one of the things that I wasn't clear on last Thursday is whether long-term disability benefits income is going to be part of the adjusted income. My initial thoughts are that taxable LTD income will be considered adjusted income in this part of the adjusted income. And the only question I have in my mind is whether non-taxable LTD income would be considered part of your adjusted income. My gut tells me it probably will, but I am not 100% sure. That is something I need to figure out. And maybe I'll figure it out by tomorrow. How about that? Let me just see. LTD adjusted income. We will be able to figure it out because this adjusted income is a well litigated concept of the part of the Tax Act. So when you have these definitions within the Tax Act, stuff like adjusted income, people go to tax. There is a tax court, believe it or not. There's a thing called the tax court. So people go to the tax court. That's where you fight our Revenue Canada over tax write-offs and these types of things. I haven't looked yet, but I have no doubt that there will be lots of cases in there that have fought over what is and is not adjusted income. Because if people got audited, maybe Revenue Canada would have said, oh, your taxes you owed more taxes because you forgot to include all this stuff that should be part of your adjusted income. Like, well, taxable long-term disability would probably be included, but non-taxable LTD is not part of your taxable income. And I think it's probably not part of your adjusted income. Now, again, I don't want to give people advice because tax is not my area, to be quite frank, and it's very complicated. So I'm going to try to figure it out. Worst case scenario, I'll try to reach out to a tax lawyer, see if they can throw me a bone here and give me some idea. But we'll get it straightened out at some point. Any other questions people have for LTD, CPP, let me know. I'm free to be here a bit longer, but if it's not going to be a long stream today, I can always shut it down. And we'll be back here tomorrow. I had a faster presentation today, so I'll have to, maybe what I'll do is have one as a backup just in case there's not as many questions from people. While we're waiting, I will say, just to plug my books here, this is the book I wrote on CPP Disability. It's back here. People are asking, is that like a fake background? That is a real background. It's my real lawyer-looking background. This is the book here, Beginner's Guide to CPP Disability. I rewrote it, I think, for 2020. Oh, no, 2023 is when I rewrote it. Yeah. So it's been updated. It's a good book. I was going to say it's not bad. I think it's better than not bad. It's actually pretty good. It answers a lot of questions, particularly some of the things that I updated was the section on, I updated the section part 6 after approval because there are all these things that come up after. So the tax section in here got updated. There's a lot of tax problems that people with CPP can get into. And I kind of talk about it in here. There can be a weird scenario where you can get taxed on CPP money that you don't get. And so it's important to know how to deal with that issue. That can come up if you're on long-term disability and you owe retroactive benefits from your long-term from CPP. So basically you get your retroactive payment. You don't get it because Service Canada sends it to the long-term disability benefits provider as an overpayment, but you still get a bill, a T4, and Revenue Canada wants you to pay taxes on that money that you didn't get. Well, I explain what to do in here in that situation. There is a way to not be taxed on that money, but you have to kind of go through the right process. And I've kind of set it out in my book here in that on page 94, 95, talking about being taxed on money you didn't get. And also this section goes through overpayments, going back to work, all that kind of stuff. What if I move or go on vacation? I talk about that. The other book I've got is this one here, the workbook. Oh, I got a copy of that kicking around here somewhere. Maybe I don't. Thought I did. Yeah, I don't know. Oh yeah, there it is up. I'll get it later. But yeah, I have a copy of that workbook. It's a little bigger. It goes through line by line through the application. So if you're doing the CPP application, it takes you through, and it's meant for you to like work. It's a workbook. So you go through all the sections of this workbook, and it helps you brainstorm and get ready to actually fill out the actual application. So I would put that in there as stuff that people can look at as well. All righty. Sammy's got a question. My pension income includes a bridge benefit. Can I get the bridge benefit if I'm on CPP? Boy, that I can't answer without seeing the actual wording. I do know that some of these bridge benefits do interact with CPP. So you have to, the best thing to do, Sammy, is to talk with your pension administrator, whoever administers the pension. It's not your employer typically, and just put that right to them and let them clarify for you. These pension things are so particular to the pension in question, but I have heard of the bridge benefits, bridge pensions, and sometimes they can interact with CPP. So it can affect. You'd still get the CPP, but it might cause your pension amount that you're getting to go down or something like that. Let me just see here. I'm going to check and see if there's any new updates on the Canada Disability Benefit. No, I don't see anything new here. Yeah. No, there's nothing new there. I'm working on writing an appeal brief for a client. We're going to the tribunal on her case, so I've been working on that a bit this afternoon. I'll be working on that probably this evening and tomorrow. We have to write these briefs. A brief is just like the summary, a written summary that you give the judge outlining all the facts and evidence in our favor, and we will then also argue why we believe that they should approve the benefit. We also go through the arguments given by Service Canada and why we think those are wrong. That's a very important document. So if you are going to do a hearing, it is very important to give a written summary to the judge ahead of the hearing. There's a deadline to do it. and you really should. It really helps the judge. They like having it because just being presented with this whole the way CPP disability hearings work is you compile all these documents and they create them into a booklet. They call it the hearing file, but it can be thousands of pages. And to just if you're the judge that just lands on your desk, it's good to have like an overview and a summary. And it's very persuasive to do it because you can point them to all of the documents in your favor and help shape the story in their mind of what the right story in their mind of why you should be approved here. Otherwise, it's very dangerous. I used to call it the dump truck approach, which is not a good approach, where you would just have picture all your documents just loosely thrown into the back of a dump truck, and you just sort of back it up and like dump it at the feet of the judge, and you're requiring them to like go through all the papers and put all the pieces together. That is not as effective a way. Sometimes that will work because they will put the pieces all together, but you have to be it's very dangerous to do that because they can overlook or not really appreciate very important facts in your favor. Or if they're inclined not, for whatever reason, like people have biases, they can be conscious or unconscious. But if someone has kind of an unconscious bias, you can then fall victim to something called confirmation bias, where you will tend to look for and see things that reaffirm what you already believe. So that's dangerous. If you just throw everything to them, they're more likely to overlook things that go against what they believe, even if they're favorable to you. It's harder for them to overlook it if you present it all out in a document that's easy to read, that they can read over and gives them an overview. So these hearing briefs are usually, I try to keep them there were days when I used to write them 20 pages or so, but 10 pages would be the most. That includes like double spacing. So really it's like a 5 or 6 page summary document that just sort of gives an overview and points to the key evidence and gives references. So like the hearing file that you use with these hearings, it's all page numbered. So you would write this brief and you would mention reports and information, and you would cite where to find it in the documents, the page number in the document. So that makes it easy for the judge. All right, another question here from, I don't know if that is Mina. I'm sure I'm butchering it. It might not even be a real name. You never know with YouTube, right? Will the LTD insurer claw back the Canada Disability benefit? Do you foresee the insurer deducted if it's approved? I mean, if we take the insurers and the Liberals if we take them for what they said, then the answer to this would be no. So the question is, do you trust insurance companies in the Liberal Party of Canada? If you do, then you should sleep well at night knowing they're not going to deduct this benefit. If you're like me and you don't really trust any political party, and you definitely don't trust insurance companies, then you do have some concerns about this, but let's see how it plays out. Likely they will not deduct it, at least not anytime in the near future. They certainly left it open that they could, even though they claim they never would, but they definitely they left it open that they could, so they could at some point. It would have been good to have that outlawed right in the regulations, but I won't go into all the reasons, but that wasn't done. That was chose not to have done. I had a good victory, a very good victory recently with a client. She was quite emotional, which is always it's always rough. And we found out. So what happened is we did her hearing. We did her hearing a few months ago, and it was pretty rough. It was pretty rough to the point that I thought about filing a complaint against the tribunal judge as being unprofessional and biased and this kind of thing. That's always a tough thing to want to do because you don't really want to antagonize judges. Like I have to hear from them. I have my personal reasons for not wanting to antagonize a judge, but I also have a role as an advocate. So, when I'm advocating for a client, my personal reasons for doing things is not always as important as what makes the most sense for this client. So I decided that I would not report the judge. I would wait and see what the decision was, because this particular judge has been very prickly, I would say, before, but had sometimes come back in favor of my clients, even though, but this time was quite a lot worse than usual. And they did come back and deny my client the benefits. So that's when I thought, okay, well, we do have another appeal we can do, and I'll have to think of whether I'm going to file a complaint. So while that was all in the process, when you lose at the tribunal, so we lost at the tribunal, which is not great. When you lose at the tribunal, there is like a second kick at the can. There is the appeal division of the tribunal. Now, really, your best chance to win is at the trial division. That's the first court hearing that you have. So we lost at that hearing. Then what you can do is you can apply to the appeals division and ask them you ask permission for them to hear your case, and they don't have to hear it. You have to point out there has to be grounds that the judge below made an error in the law or made an error in the facts. You have to show why that's the case. And if the appeal judge thinks that there's some grounds for that, they will agree to at least hear the case. And then they'll decide. They could still rule in the same way as the other judge, but they will at least. So you have to kind of get through the door. It's called getting leave to appeal. So we filed our leave to appeal, and I let loose in the leave to appeal. I did criticize the judge and things in there. So I wrote a very lengthy leave to appeal, pointing out all the reasons why this was unfair. It made no sense, this decision, that kind of thing. And lo and behold, the judge, you do this all in writing. So I haven't met with the judge yet for the appeal division. They wrote back accepting that they agreed with me to the extent that they would agree to hear the case. So they granted us our leave to appeal. Service Canada's lawyer wanted the judge to give reasons. So the judge wrote their reasons of why they agreed to grant the leave to appeal. And after the other lawyer got those reasons, Service Canada decided to approve the case. Okay. So that shows you how I won't say insane, but like how crazy this whole thing can be. Like, we went from losing in court to appealing, giving reasons why we disagreed with the judge. And on the leave to appeal, the judge grants the leave to appeal, gives reasons why, and then Service Canada turns around and says, okay, yeah, we'll just approve the case, is literally what happened. It's just like, are you kidding me? So how it worked is they asked for, once you're at that level, you can ask for, they can't just approve the case. Service Canada just can't prove the case. They have to have agreement from us and the court and all these things. So they asked for a settlement conference with the judge at the appeal division, and that is what we did. So we showed up. I reassured my client that the only reason that other lawyer would be asking for this is to say that they want to approve the case. And it's the most efficient way to do it because everybody's on the call and the judge can agree, we can agree, and then it's done. Whereas it's a little more difficult to do by paper and writing. And it turned out that was the case. So they did approve. The lawyer said that they wanted to approve the case. Well, all you have to agree on is like, do we agree on the dates that the benefits start and the date of onset? We agreed on all that. So they approved it. The judge approved it. And yeah, my client was kind of in shock because you got to think from her point of view, she went from feeling so bad after that hearing and me saying, well, this judge can be that kind of prickly, but sometimes they come back in our favor and then come back with a very negative, it's not great because when you get a negative thing written about you, it's in writing. So like the judge writes negative things about you. It really took the wind out of her sails. And I tried to stay positive, but I also know like how hard it is to win on the appeals. So I told her to stay positive. We're going to try to do this. And I really thought we would win on the appeals. I'll be honest with you, because I felt like the trial judge, for whatever reason, maybe they're having a bad day, but from my point of view, I just wasn't happy with the judge, honestly. You have to be careful how much I criticize judges because, again, they are allowed a certain range, which is acceptable behavior. And I think this judge still was in that range of what's acceptable. I felt it was more aggressive than it would be typically normal for a judge in these kind of cases. But it is what it is. Justice was still served as we won on the appeal. So the client was quite happy. I was quite happy. But it does show like you do have the extent you have to go, because she could have easily just given up at losing, because doing a leave for appeal is pretty complicated. It's difficult. You've got to now you got to find errors that were made and these types of things. So it is a system where you just have to keep pushing forward. And even though the chances of winning on appeal are low, this shows you that it can happen. All right. Let's see if we got any other questions. Oh, we got Robert saying thank you. Thank you, sir. I thank you for showing up. I thank you for showing up. If I got any other stories I can tell. I have to be careful with my stories because a lot of it is like client confidentiality. So I can't really talk about. That's one of the terrible things of being a lawyer is you can't really talk about your work a lot because you're representing people and there's confidentiality. So sometimes I can talk about general things, generalities, but you still have to be careful because it could, you don't want to give any people's personal information away. It's the first thing when I was a lawyer, you have to do a year of apprenticeship, and it still sticks with me. The lawyer I apprenticed with, he sat me down. He said, David, I'm going to tell you 2 things to give you a successful career as a lawyer. First of all, don't go out and try to buy all these expensive cars and houses and go bankrupt, which is what a lot of lawyers will do. And he said, the second thing is just keep your effing mouth shut. He said, if you avoid those things, you'll have a long, successful career as a lawyer if you can avoid doing those 2 types of things. So I've tried to follow that. His name was Robert Purdy. He's a lawyer in Nova Scotia, a well-known lawyer. He's still working, though he's probably closer to retirement than away from it, but very good guy. It's just always stuck with me that keep your effing mouth shut. But that's what then I tell new lawyers the same thing, because it's the one thing will get lawyers in trouble because it's interesting. A lot of things we do is very interesting and it is fun to talk about, but you do have to keep your effing mouth shut. You can imagine you're out talking about your case and the client or someone is in there listening. Like, it's just terrible. Not a good thing. Okay, folks. Well, I think we're getting near the end. If you were interested in getting into my books, if you don't already have them, there's links down below that they will be down below. I think they already are down below in the description of this video. I'll be back tomorrow. What am I talking about tomorrow? Give me a second here. I'm going to figure it out. I'm going to figure out what tomorrow is. Tomorrow is, returning. Someone asked for this last week. Tomorrow is returning to work after long-term disability. So I'm going to talk about tomorrow. We're going to talk about the process of when you're on long-term disability, attempting to return back to work, either being forced by the insurance company or if you want to initiate it yourself. We'll talk about how it works, what your obligations are, most importantly, how you can protect yourself so that if the return to work is unsuccessful, you set yourself up with the best chance to get put back on long-term disability, either by voluntarily the insurance company agreeing or setting yourself up in a good situation so that you could get a judge to force them to put you back on. And then on Wednesday, I'm going to be talking about what is severance. So that's an employment kind of question. We'll be talking about what is severance when you are leaving a job. Like what are you entitled to? What type of money is included when people say, I want to get severance pay? Like, what is that? How is it calculated? What are the types of money you can get? What amounts of money do people get? What affects how much you get? This kind of thing. So we'll talk about that. I'll check one more time to see if there's any last questions. It does not appear to be. And yeah, that's it. So we'll see you tomorrow, folks, or we'll see you back here next week on Monday if you're only interested in the CPP stuff. Take care. Have a good night.